Good morning, madam.
A very good morning to all of you. Please.
Thank you. Good morning, everyone. Honorable judges, respected principal, esteemed faculty members, distinguished guests, and my dear fellow students. It is my privilege to warmly welcome you all to the Section 498A case finals of the intra Moot court competition of 2025 organized by ISLAMIA College of Law. Today marks the culmination of days of preparation, rigorous arguments, and spirited advocacy by our participants. The atmosphere here is charged with anticipation as we witness the final battle of legal minds. To begin this special occasion, may I request Ms. Huda Yafai and Ishrat Begum to kindly come forward and facilitate our honorable chief guest and judge with a bouquet as a token of our respect and gratitude. Thank you, ma'am, for your gracious presence. We are truly honored.
But when we are on bench, we are not supposed to be honored. Take care of these
Sure.
small things.
Sure.
Thank you.
Now, let me briefly explain today's competition structure for the benefit of the spectators. Today's final moot proposition is based on use and misuse of Section 498A IPC. The finalists for this event are Team 1 and Team 2. To ensure fairness, each team will be allotted 30 minutes to present their arguments.
I request Mr. Overseas to take his seat on the dais.
Oh, yes, sir. क्या मैडम? Pause. Thank you, sir. Thank you very much. I repeat, let me briefly explain today's competition structure for the benefit of the spectators. Today's final mode proposition is based on use and misuse of section 498A IPC. The finalists for this event are team 1 and team 2. Each team will be allotted 30 minutes to present their arguments. The time will be strictly monitored and cue cards will be shown to indicate the remaining time. And 5 minutes will be given for rebuttals and surrebuttals. The petitioner will be seated on the left side of the bench and the respondent on the right side. After each team has made its submissions, our esteemed judges will provide their valuable feedback and observations. Respected judges, the moot proposition, the memorials, and the scorecards are placed before you for your kind perusal. Each team has been allotted 30 minutes for their submissions. After each round, a 5 to 10 minutes break will be given exclusively for your evaluation and scoring. Following this, the results of the previous moot court competition in injunction case will be announced today, while the valedictory ceremony will be conducted on the orientation day. Additionally, the certificates of participation will be issued to all participants today after the judges' feedback session. I will reiterate, the petitioner will be seated on the left side of the bench and the respondent on the right side, which includes speakers and the researcher as well. With the team settled, we are all set to begin. If the honorable bench permits, may I now invite the petitioner's counsel to commence their arguments.
May it please the court, I, counsel 1, respectfully request permission to approach.
माइक ऑन करो.
My team will be addressing you as your honor. I am approaching on behalf of my client, the petitioner, and seek permission to submit the facts of the case. May I? Your honor, please refer to page number 10, paragraph 1, which states that respondent herself admitted before the sessions court through an affidavit that her allegations were made in the heat of the moment, were exaggerated and partially false, demonstrating that the complaint was retaliatory, not genuine. Your honor, neither the FIR nor the prosecution produced credible material or witnesses establishing any demand for dowry or harassment. This case rested solely on Ankita's uncorroborated and later retracted testimony. Your honor, the police arrested Aditya and his aged parents 62 and 68 and his young sister 25 without preliminary investigation, in violation of safeguards laid down in Arnesh Kumar vs. State of Bihar 2014. This amounted to arbitrary deprivation of liberty under Article 21 of the Constitution of India. The arrest and the media coverage caused serious reputational harm and professional consequences for Aditya, including workplace humiliation and loss of career opportunities, a violation of his right to dignity. Your Honor, since the allegations were false, malicious, by the personal frustration over Aditya's refusal to settle abroad, this case amounts to malicious prosecution. Therefore, the Joshi family is entitled to compensation and judicial guidelines are necessary to prevent misuse of Section 498A IPC while protecting innocent families. Your Honor, if you are satisfied with my fact, may I advance towards the issues of the case?
Yes, please.
Your Honor, shall I address the issue? Whether the allegation made by the complainant under Section 498A IPC constitute a misuse of law, thereby necessitating judicial scrutiny and intervention to prevent wrongful prosecution of innocent individuals. Your Honor, the issue 2 raises a question: what specific judicial safeguards can be instituted to prevent the misuse of matrimonial laws, particularly Section 498A IPC, ensuring that the legal framework serves its intended purpose without infringing upon the right of the accused. Much obliged, Your Honor, the remaining issues will be addressed by my co-counsel. If you are satisfied with my preceding issue, shall I proceed with my arguments? Kindly direct your attention towards page number 14, paragraph 1. Your Honor, the Section 498A is always associated with the term legal terrorism. The petitioner submits that the Section 498A originally enacted to protect a woman from grave issues of domestic violence and dowry harassment, but it has increasingly been misused as a weapon against innocent family members. The Honorable Supreme Court in Sushil Kumar Sharma v. Union of India has categorically observed that although Section 498A was introduced to combat cruelty against women, but it also asserts that misuse may lead to legal terrorism and such misuse cannot be permitted to wreak personal vendetta. Your Honor, indeed there is a scope of growing tendency of false complaints and judicial safeguards. The paragraph 2 highlights the misuse of Section 498A through false complaint and frivolous litigations, which not only waste judicial time but also harm chances of reconciliation between families. Your Honor, from the compendium, please refer to the page number 4. Your Honor, in compendium page number 4, the second paragraph clearly explains that in Anish Kumar v. State of Bihar 2014, emphasized that police must...
Just a minute, there is nothing on page number 4.
Sir,
These are the abbreviations.
in compendium, Your Honor. The compendium has been presented here.
One more file is.
Please.
The second para clearly states that the Supreme Court in Anish Kumar v. State of Bihar 2014 emphasized that police must issue a notice under Section 41A CRPC before arrest to prevent unnecessary harassment of innocent person. Your Honor, I kindly request your attention in memorial, page number 15. Page number of memorial. 15 page number. The para 1. The paragraph. Your Honor, the paragraph 1 says that misuse of law harms the reputation of the accused and wastes court's time. it also takes away resources from real victims of domestic violence. The petitioner asks the court to stop this misuse so the law is used for its true purpose. And Your Honor, the fourth para showcases the guidelines implemented in Uttar Pradesh. Although these measures stem for judicial rather than legislative action, they are binding and enforceable across Uttar Pradesh. In effect, the state has adopted the following approach. Firstly, no immediate arrest, a 2-month cooling of appeals, mandatory referral to FWCs of neutral assessment, policy level training and structured oversight for police and magistracy, safeguards limited to less serious offence, not applicable in case involving grievous harm. Your Honor, the page number 16, which is issue 2, the paragraph 1 refers, under section 498A, the responsibility to prove cruelty or harassment is on the complainant. Allegations alone are not enough. There must be strong and credible evidence. The Supreme Court in case Subbarao vs. State of Telangana said that trial must rely on proof, not suspicion. Without such proof, wrongful arrest takes place and the accused suffers unnecessary mental stress. Therefore, arrest under section 498A should be based on clear and objective material evidence. Your Honor, the paragraph 2 has been presented the statistical data on misuse of section 498A. The same page, page number 16, paragraph 2. The Crime in India 2012 statistics by NCRB, which is National Crime Record Bureau, shows that 1,97,762 persons were arrested under section 498A in 2012, which is 9.4% more than 2011. Nearly 1/4 of those arrested were women, mostly relatives of the husband. Section 498A cases formed 6% of total IPC arrests and 4.5% of overall IPC crimes, more than any other except thefts and hurt. The rate of charge sheeting in case under section 498A IPC is as high as 93.6%, while the conviction rate is only 15%, which is lowest across all heads. As many as 3,72,706 cases are pending trial, of which on court current estimate nearly 3,17,000 are likely to result in acquittal. Your Honor, please refer to the next page, which is about judicial recognition on frivolous cases. Your Honor, this paragraph stresses that court must apply a higher standard of proof to prevent misuse of section 498A. It cites the state of Karnataka versus L. Muniswamy, where the Supreme Court held that proceeding without sufficient grounds for conviction should not continue. The petitioner highlights that lack of strict scrutiny leads to miscarriage of justice and harassment of innocent. This concern was also ensured in Rajesh Sharma versus State of Uttar Pradesh, where the court recommended guidelines to curb false or exaggerated complaints were under section 498A. Your Honor, there is a need of call for judicial guidelines on evidence. The petitioner therefore calls upon the Honorable Court to establish guidelines for the evaluation of evidence in such cases, thereby safeguarding the rights of the accused while ensuring that genuine victims of domestic violence are not denied justice. Your Honor, I want to prove here about the petitioner, which is shown under Citizenship Act. Aditya, the husband, it is the evidence or the point presented by me. In the compendium, it is written in compendium from last page number 79. Yes. Which is affidavit presented by Ankita Sharma, and whereas in the next page, the Senior Citizenship Act 2007 has been presented, which shows the duty of children towards parents. Your Honor, the husband, Aditya, refused to shift abroad because he had family obligations. He had to take care of his aged parents, 62 and 68 years. Under Senior Citizens Act 2007, Aditya had a legal as well as moral duty to maintain and look after his parents. Therefore, his refusal to relocate abroad cannot be termed as cruelty towards wife, rather it was a lawful duty. Your Honor, as per Section 2 of Senior Citizenship Act 2007, any person who has attained the age of 60 years or above in a senior citizen entitled to maintenance. The petitioner parents being 62 and 68 years old clearly fall under this definition, thereby making it a statutory duty to care them. Your Honor, my co-counsel will further proceed the case.
Greetings. Your Honor, the counsel number 2 is approaching. May I?
Yes, please.
Much obliged. If it pleases you and with the kind permission of yours, I would like to exaggerate the issues. May I?
Yes, please.
Your Honor, please refer page 18 which deals with my issue. Your Honor, I would like to ask this Honorable Court what are the judicial cautions against these exaggerated complaints. Your Honor, I and my client highlights that the law must differentiate between the authentic cases of domestic violence and the fabricated ones. Your Honor, to substantiate this question, I would like you to refer the page 59 of compendium. Which deals with my case Preeti Gupta versus State of UP. Your Honor, here the court observed the same exaggerated scenes of the incidents reflected under the complaint under this section 498A and caution against the misuse which are falsely implicate the family members. Your Honor, not only this one case, in the another case of case Surendran versus State of Kerala. Your Honor, please now have a look on the memorial, page 18.
Page number?
18. 18. Your Honor, the court emphasized the well-settled principle that the evidence tendered by or related or interest witness cannot be discarded on the ground alone. Your Honor, now I must say there should be a need for judicial measures for filtering these false cases. Your Honor, in fact, I and my client argues this honorable court for approaching more rigorously in evaluating the evidence under this section 498A. To vindicate this, I would like you to refer the another case of Rajesh Sharma versus UP. Your Honor, here the Supreme Court clearly gave the guidelines for constituting the FWCs, Family Welfare Committees, for scrutinizing the complaints before arrest. Your Honor, now, I would like you to direct your attention towards the main issue that the risk of automatic arrest and chilling effect on justice or legal process. It deals in page number 19, Your Honor. May I?
Yes,
Your Honor, I can emphasize that if there is a failure to establish a distinction between the authentic cases and the false and exaggerated cases, that can lead to a chilling effect on our legal process. Your Honor, where the individuals may get deterred from taking justice just due to fear of being falsely accused. Your Honor, this same concern was shown in the case Arnesh Kumar versus State of Bihar. Your Honor, here the Supreme Court has given the clear guidelines which stated that the evidence, without any adequate material evidence, the defeat of purpose and justice. Automatic arrest can defeat the purpose of justice and endanger the individual's liberty. Your Honor, now the main issue which I would like you to show, the social and personal repercussion of false allegation, which deals on page number 19, and the psychological and social consequences of false allegation, which deals on page number 21. Your Honor, I seek permission. Can I speak in my own language?
yes, please.
Thank you. Much obliged, Your Honor. Your Honor, my first question to this Honorable Court and this respondent is, Your Honor, what are the judicial, is this the constitutional morality of section 498 is so small that a woman in a frustration can misuse it? No, Your Honor, it's not so small. A woman in frustration, in a heat of moment, cannot misuse any law. Your Honor, एक झूठा इल्ज़ाम, एक बेबुनियाद इल्ज़ाम काफ़ी है मेरे क्लाइंट को रातों रात मुजरिम साबित करने के लिए? योर ऑनर, उसके 68 साला पेरेंट्स, 25 साला बहन, वो तीनों सोशल आउटकास्ट हो गए. योर ऑनर, ये साइकोलॉजिकल एंड सोशल रेप्लिकेशन बता रही हूँ मैं आपको. मेरा क्लाइंट का 10 साला बेदाग करियर, योर ऑनर, ख़ानदान का आइडियल बेटा जिसकी खुददारी, सच्चाई, ईमानदारी सब खड़ी तमाशा देखती रह गई, और योर ऑनर एक लड़की का लगाया हुआ झूठा इल्ज़ाम जीत गया. योर ऑनर, जब अरेस्ट हुई, क्या मेरे क्लाइंट से किसी ने न्यूट्रलिटी के साथ सफाई मांगा? नहीं योर ऑनर, नहीं मांगा. योर ऑनर, अदालती कार्रवाई से पहले पब्लिक और मीडिया ट्रायल ने उसे मुजरिम साबित कर दिया. योर ऑनर, ये मुआशरा, योर ऑनर, ये सोसाइटी जो बुनियादी तौर पर तमाशबीन है, उससे क्या इंसाफ की जा सकती है जो हकायत से ज़्यादा सनसनी पर इंटरेस्ट रखता है? योर ऑनर, मेरा क्लाइंट एक प्रोग्रेसिव मैन है जिसको विक्टिम ब्लेमिंग या विक्टिम शेमिंग का गेम नहीं खेल रहा है. योर ऑनर, बस ये उसका यही कंसर्न है इस ऑनरेबल कोर्ट से कि आने वाले टाइम में किसी मर्द के साथ ऐसा अन्याय ना हो. योर ऑनर, वुमेन हरासमेंट एंड वुमेन क्रूएल्टी हमारे मुआशरे की बहुत बड़ी हकीकत है, इसमें कोई दोहराई नहीं. योर ऑनर, और इस केस में ना वुमेन हरास हुई है, ना वुमेन के साथ कोई क्रूएल्टी हुई है. योर ऑनर, एक बेसिक सा क्वेश्चन वकील इस्तिखाज़ा से और इस ऑनरेबल कोर्ट से कि योर ऑनर, हस्बैंड एंड वाइफ, क्या एक हस्बैंड एंड वाइफ के रिलेशनशिप में कंसर्न बताना गलत है? इफ़ यस योर ऑनर, गलत है. इफ़ नहीं योर ऑनर, गलत नहीं है. योर ऑनर, मेरा क्लाइंट यहाँ पर हस्बैंड अपनी वाइफ को कंसर्न बता रहा था अबाउट द अनसर्टेनिटीज ऑफ द अब्रॉड एम्प्लॉयमेंट, योर ऑनर, फॉर विच द रेस्पोंडेंट हैज़ टेकन इट एज हरासमेंट. योर ऑनर, क्या हरासमेंट का डेफिनेशन इतना ही है कि किसी को एम्प्लॉयमेंट से रोका जाए तो उसके साथ हरासमेंट हो जाए? नहीं योर ऑनर. योर ऑनर, वुमेन हरासमेंट और वुमेन क्रूएल्टी बहुत बड़ी चीज़ है जो इस सोसाइटी की बहुत बड़ी हकीकत है, और इस जो बहुत बड़ी हकीकत है और इसमें कोई दोहराई नहीं. योर ऑनर, बट एक इल्ज़ाम कैसा साबित कर सकता है योर ऑनर कि मेरा क्लाइंट मुजरिम है? योर ऑनर, तहकीक, इस इल्ज़ाम को बिना तहकीक के कैसे सच्चाई माना जा सकता है? योर ऑनर, तहकीक करना रियासत की जिम्मेदारी है. योर ऑनर, हर फरीक को अपनी सफाई में पूरा मौका देना ये कानूनी इदारों की जिम्मेदारी है योर ऑनर, और हर फरीक की जानो माल, उसकी डिग्निटी, उसका ऑनर, सेल्फ रेस्पेक्ट, लिबर्टी, उसकी हिफाजत करना ये अदालत की जिम्मेदारी है, चाहे वो औरत हो या मर्द. योर ऑनर, मैं ये नहीं कहती योर ऑनर योर ऑनर, मैं ये नहीं कहती कि यहाँ पर औरत गलत है या मर्द गलत है। योर ऑनर, योर ऑनर, हमेशा मर्द गलत नहीं होता, औरत भी गलत हो सकती है। योर ऑनर, ये बस हमारा माइंडसेट है। अगर कोई मर्द औरत को थप्पड़ मारता है तब हम कहते हैं बड़ा जालिम मर्द है, और अगर कोई औरत किसी मर्द को थप्पड़ मारती है तब भी हम यही कहते हैं कि यकीनन मर्द बहुत बदतमीज़ होगा। योर ऑनर, हम हर हाल में मर्द को ही गलत ठहराते हैं। योर ऑनर, मैं ये नहीं कहती योर ऑनर कि हर औरत गलत है। योर ऑनर, अंकिता जैसी औरतें भी हैं जो किसी भी मर्द के साथ अन्याय करती है सिर्फ अपने फ़ायदे के लिए। योर ऑनर, मैं भी एक औरत हूँ, लेकिन मुझे इस तरह का अन्याय किसी औरत करे मर्द के साथ, वो एतराज़ है। योर ऑनर, नाउ आई वुड लाइक यू टू हैव अ लुक ऑन पेज नंबर 22 ऑफ मेमोरियल। Your Honor, I would like you to direct your attention towards the constitutional safeguards under Article 14 and 21. Your Honor, Your Honor, further, I can enrich you the constitutional safeguards which are under the Article 14 and 21 of Constitution of India. Your Honor, here I can say and I can argue the allegations made without credible evidence infringe upon the accused's right to fair trial and presumption of innocence, which are the fundamental tenets of justice. Your Honor, please refer page 22, paragraph 3. Your Honor, I therefore argues this honorable court to establish a framework that balances the need for protecting women victims of domestic violence and with the imperative of safeguards of rights of the accused, thereby reinforcing the principle of justice and fairness in the legal system. Your Honor, further, I emphasize on the following framework which deals in page number 23 of memorial. Your Honor, first, police should not make an automatic arrest under section 498A. Access necessity as per the section 41 CRPC. Your Honor, all officers to be given a checklist under section 41 subsection 1 clause B, subclause 2 CRPC, and have a checklist with the reason material to be forwarded to magistrate when producing accused. Your Honor, magistrate must examine the police report and record the satisfaction before authorizing detention. If police decide not to arrest, and decision must be sent to the magistrate within 2 weeks and proposes reason recorded. Your Honor, now I would like you to refer the page page 20, Your Honor, which says that there is a judicial recognition of legal terrorism associated with this section 498A. Your Honor, I can cite the various judicial decisions that have recognized and the detrimental impact of false allegation under this section 498A on the lives of the accused. Your Honor, the Supreme Court in the case Sushil Kumar Sharma versus Union of India held that the misuse of section 498A may unleash a form of legal terrorism which causes the irreparable harm to the reputation and the dignity of innocent individual. Your Honor, further, the High Court has laid down the certain framework and the regulations on the 498A on the basis of statistical evidence of misuse and law conviction rates and judicial prudence and the legislative caution. Your Honor, I can argue this court, they should consider new developments of this misuse of section 498A. Your Honor, the first one, the Delhi's conviction rate, Your Honor, from 2021 to 2025, only 23 convictions emerged from 9,950 cases, while nearly 47% were quashed by the Delhi High Court. Your Honor, advocates continue to push for making the law compoundable and introducing technological reforms for faster resolution. Your Honor, Supreme Court advocates judicial prudence. Your Honor, Court have cautioned against using the vague allegations and urged the protective law must not misuse to harass innocent individual and emphasize the specific evidence. Your Honor, the legislative caution affirmed in April 2025, the Supreme Court upheld the constitutionality of Section 498A. Now, the Section 84 of Bharatiya Nyaya Sanhita, emphasizing that the social misuse does not warrant diluting the law, but each case must be scrutinized on its own merit. Unless you have any queries with my arguments, preceding arguments, shall I conclude it with my prayer? Yes. Much obliged, Your Honor. Sorry. Your Honor, in the light of the facts of circumstances of the present case and the arguments advanced herein above, I most respectfully pray this Honorable Court to please recognize and address the growing misuse of this section 498A IPC and ensure that the arrest and the criminal proceedings under this section 498A are carried out only upon the arise of existence of credible and substantial evidence. Your Honor, page 24. Your Honor, direct the establishment of clear guidelines to distinguish between the genuine cases of domestic violence and false or exaggerated allegations in order to uphold the integrity of the legal system. Your Honor, and affirm that the social constitutional rights of the accused under Article 14 and Article 21 of Constitution of India, ensuring that their right to fair trial and presumption of innocence and protecting from arbitrary deprivation of liberty. And Your Honor, at last grant any other relief which this Honorable Court may deem to fit in with that, in the interest of justice, equity and good conscience. And here now we rest our case, Your Honor. We are much obliged by your time. Thank you.